Good afternoon, everybody. Thank you for attending our webinar this afternoon on the recent case of TA and the Public Guardian, which was or is a decision of Mrs. Justice Leiven, in which I acted for the appellant. For those of you who don't know me, I'm Faye Collinson, barrister at King's. I'm joined here today by three very eminent speakers. From Chambers, I have Sophie Hurst. Hope you can see her on the screen. She's waving, there you go. And she's going to be giving you an overview of the case and an overview of the judge's decision at both first instance and on appeal. Then I'm going to give a very brief overview of what I think some of the key consequences or repercussions of the judgment are. And then I'm going to open up the floor to two speakers who are joining me today. So I've got Neil Davies, who is a partner and head of Court of Protection at Lanyon Bowdler Solicitors, who is my instructing solicitor in this matter. And then also Caroline Bielenska, who many of you, I'm sure, will have listened to her webinars and seminars before. She sits on the Law Society Mental Health and Disability Committee, and many of you will know she's also the author of Cretney and Lush on lasting powers of attorney, so has some really useful insight into the decision and its ramifications. So what I'll do is I will turn my mic off now, and then I will hand over to Sophie.
Thanks, Faye. Good afternoon, everyone. So as Faye said, I'm just going to start by running through the facts of the case and giving a bit of an overview of essentially what's happened. So P, known in this case as KA, was a 92-year-old woman who lived in a care home. She had three children, a daughter, TA, who was the appellant who Faye and Neil represented, and she also had two sons. In 2019, KA executed an LPA for property and affairs in favour of all three of her children on a joint and several basis. And then in 2020, KA revoked that LPA. In 2021, KA made two further LPAs, one for property and affairs and one for health and welfare. And these were both registered with the Public Guardian and appointed TA as the sole attorney. Both of the 2021 LPAs had the same certificate provider, and that certificate provider is known in the judgment as X. X was TA's ex-mother-in-law and a close family friend of KA. In September 2021, one of KA's sons, who's known in the judgment as HC, instructed solicitors with a view to seeking the revocation of the LPAs in favour of TA and executing a new LPA in favour of all three children again. The solicitor that HC instructed attended upon KA and took the view that KA lacked capacity to execute new LPAs. There followed an investigation by the Office of the Public Guardian as to the making of the 2021 LPAs in favour of TA. And following that, there was an application from the OPG to the Court of Protection seeking the revocation of the 2021 LPAs in favour of TA on the basis that they were invalid. As part of the investigation by the OPG asked X, the certificate provider, various questions, and she provided her responses in writing. I'm not sure whether it's all of the responses, but certainly a summary of the responses provided by X is actually set out in the judgment of Mrs. Justice Leiven. And by way of summary, X responded in the following terms. She set out her relationship with KA, including that she'd known her for 50 years. X said she'd last spoken to KA in December 2020, before she made the Property and Affairs LPA in January 2021. And X said she spoke to KA again in March 2021 before she made the Health and Welfare LPA in April 2021. Now, in terms of the discussions that X had with KA about the LPAs, X is reported to have written, "I just asked her if she was happy about it, and she was." X also said that she spoke to KA about it on the phone. She didn't feel that KA was under any pressure to make the LPAs. She said that KA sounded cheerful, she was in good spirits, and sounded like her normal self. X said KA did not express any wishes about how her attorneys should act. She then went on to say that TA had always been a caring daughter and that TA and KA had a loving and close relationship. X said that TA had always acted in KA's best interests. A Court of Protection special visitor was instructed to attend upon KA and did so on, it was in December 2021. And a summary of the special visitor's notes are also set out in Mrs. Justice Leiven's judgment. And in short, the special visitor said that when KA was asked who she would trust most to help her manage her money, KA replied her son, HC. She said that HC was an accountant and the eldest child. When the special visitor told KA she'd made an LPA, naming TA only, KA said she wanted all three of her children to agree on decisions. KA was unable to offer any reasons or explanation for appointing TA only. And when KA was asked if she was happy for TA to have sole responsibility, she repeated that no, she wanted all three of her children to make decisions together. And that's what she had always said that she'd wanted. The application of the OPG saying that the LPAs of 2021 were invalid came before Her Honour Judge McCabe. And the key issue really was the extent of the duties owed by an individual who provides a certificate under paragraph 2(1)(e) of Schedule 1 of the Mental Capacity Act 2005. The key question being, is the duty of the certificate provider simply to provide a certificate, or is the duty to hold an opinion on those matters set out in paragraph 2(1)(e), which is set out on the slide there? The view reached by Her Honour Judge McCabe is set out within the judgment of Mrs. Justice Leiven from the appeal. And I've included some of the key quotes from Her Honour Judge McCabe's judgment there on the slide. Importantly, that first instance judge determined that the certificate provider does have a duty to hold opinions and satisfy themselves of those matters set out in paragraph 2(1)(e). Within her judgment, Her Honour Judge McCabe stated that the certificate provider is required to provide an opinion, not just witness a signature, that in reading paragraph 2(1)(e) as ordinary words plainly requires the certificate provider to take some steps to satisfy themselves of those matters set out therein, and that in exercising its power under Section 22 of the Mental Capacity Act to determine whether one or more of the requirements for creating an LPA have been met, the court must be entitled to look for evidence that the requirements in paragraph 2(1)(e) have been met. The first instance judge said that if the certificate provider does not satisfy themselves of those matters set out in 2(1)(e), then they are out with the requirements of the section. She was not satisfied that X asking KA if she was happy with the LPA was enough, and therefore deemed the LPAs to be invalid. TA appealed this decision, and the matter came before Mrs. Justice Leiven. Following submissions on behalf of TA and the Office of the Public Guardian, Mrs. Justice Leiven agreed that the position adopted by Her Honour Judge McCabe was correct, and the appeal was dismissed. Mrs. Justice Leiven said that the issue was one of statutory interpretation, and found firstly that paragraph 2(1)(e) explicitly requires a certificate to have specific content, namely an opinion on the three matters outlined within 2(1)(e). Secondly, that a valid certificate must therefore be based on an opinion about those matters. that if evidence demonstrates the certificate provider did not have such an opinion, the certificate would be invalid, and that the court is entitled to check that the requisite opinion was formed. Mrs. Justice Leiven said that paragraph 2(1)(e) goes beyond capacity, and the certificate itself is an important part of the procedure to ensure that a valid instrument has been entered, and that it provides safeguards that the donor understands the instrument, is not subject to fraud or undue influence, and there are no other barriers to the LPA. So that's what the judgment says. But what does this mean for us as practitioners? Well, I'm going to hand over to Faye now, and she's going to explore that a bit further before we go on to a panel discussion with everyone else on the call.
Okay, so I'm going to deal with what I think are the consequences, and it's always difficult to objectively analyse a case in which you lost and had a big defeat, but I'll do my best to do that. One thing I want to make clear before I jump into this is this: the OPG's original COP1 application was on two bases. She said that the certificate provider hadn't carried out sufficient checks on capacity, undue influence, etc., etc. And that meant that the certificate didn't comply with paragraph 2(1)(e). And they went on to argue that not only just the certificate provider need to show that they had an opinion, but that the opinion was properly formed by that person. And so the OPGs, the focus of their argument appeared, certainly to me, that they were questioning the sort of integrity or reliability of the process adopted by the certificate provider in coming to that view. Our argument wasn't that the certificate provider's opinion doesn't matter. And I have to say, I don't think that comes over as clearly in the judgment as one might hope. But what we were saying was that the reliability of the certificate provider's opinion really becomes relevant when one is challenging the validity of an LPA on the basis of capacity, or as much less commonly under undue influence. So the outcome of the decision, I think, has these ramifications, and I'm sure that Caroline and Neil will expand on these if I've missed any. But in order for the certificate to be valid, and that is a piece of language that's been parachuted into the legislation by the judges, because nowhere is it referenced in either the MCA or the attorney regulations, which are highly prescriptive. And there's no reference to the concept of it being a valid opinion or a valid certificate. But if you want to show that there is a valid certificate, you've got to have evidence of a valid opinion that has been properly formed. And so I think that has these particular consequences. Just showing that the certificate has been signed by the certificate provider is in and of itself not going to be sufficient. Whereas historically, in cases that I have dealt with, it has been considered to be sufficient. And the position now is that if there is ever an inquiry into the certificate or its validity, and now I think there will be many more inquiries into the certificate provider, they will have to set out the process that they went through in order to satisfy themselves of those three matters in paragraph 2(1)(e). And so what does that mean for many of you listening who I know are private client solicitors? Well, I think it's sort of twofold, really. One of the key things I think that you will now have to do is, in every case of a donor, will have to positively set out in an attendance note that you went through X, Y, and Z, and probably even go as far to set out maybe your questioning of that person, because the OPG were effectively saying that the certificate provider hadn't demonstrated that she had asked the right questions of the donor. Now, I know many of you already do that in practice with certain types of donors. So you might, for example, have a donor who is quite elderly or is suffering from dementia, and so you perhaps approach your files a bit more defensively than you might do if you were taking instructions from me, for example, for a lasting power of attorney. But I think the position is now different. Even if you have a client who is obviously capacitous and not subject to undue influence and is a younger individual, I think now in your attendance notes, you will have to be going through that process and recording it in case there is a later challenge to it. The second thing I think that will need to happen is that where, for example, you rely on the donor to actually deal with the execution of the lasting power of attorney. So you've prepared it and you are not acting as a certificate provider yourself, but you're sending the document out to the donor to arrange that themselves. Many of you, I know, send out a sort of letter with either a will or the lasting power of attorney saying, these are the requirements and you must do X, Y, and Z. I think now if you're going to be doing that, you need to be setting out within those letters the expectation of the process that the certificate or the lay certificate provider will need to go through, and perhaps even go as far to encourage that certificate provider to make their own records of it. Because one of the real difficulties with cases like this is if there is a much later challenge to the certificate and the individual's memory just fails them because of the passage of time. The second aspect is I personally think it's going to make it quite difficult for lay individuals, and I'll put brackets, and GPs to act as the certificate provider going forward. I'm all for having robust processes in place to ensure compliance with documents, but I think the real bugbear here is that nowhere is there set out by the OPG or the legislation what is expected of a lay certificate provider. And that to me is where there is a real unfairness in this, because asking your average person on the street to go through this process of checking somebody's capacity and arguably their actual understanding and that an individual wasn't subject to undue influence is quite a big task. And so I think that it's going to make it more difficult for lay individuals to act as certificate providers. Now, of course, with all the consultations that have been going forward, and Caroline will know much more about that than I do, there may well be some intention to set that out more prescriptively for individuals. But I put GPs because, I've seen from my contested hearings, lots of GPs are asked to sign certificates. And then when I've actually cross-examined them, it becomes abundantly clear that they have had perhaps a 5-minute consultation with the person. And because they see them quite regularly, they might be a bit younger and have no history of an impairment, they just sign the certificate, and then there's no real record of why and on what basis they formulated the view. And that's where the evidence needs to go to going forward. So if you are advising a client to go see their GP, for example, to act as a certificate provider, I think it would be sensible for the GP to be provided with some level of understanding of what is expected of them. So it may well be they decline to do that going forwards. The third aspect is that and this is something I raised during the appeal, or although it doesn't really feature in the judgment, is that the outcome, I think, is that there are going to be many lasting power of attorneys that are now invalid on a formal basis rather than a substantive basis, even where a donor retains capacity, wasn't subject to undue influence, etc. So, for example, you might have someone like me or Sophie, who are relatively, I think I can still put myself in that category, young, and they execute a lasting power of attorney, and we just, for example, ask our neighbour to act as a certificate provider. Now, I would hope you'd all agree with me that Sophie and I are retain capacity to execute those outlasting power of attorneys, assuming that we're not subject to any undue influence or there's any other reason we shouldn't execute those. But say our neighbour does not a very good job of it, say they don't actually apply their mind to those questions or that process that TA now requires a certificate provider to do, then tragically one of us has an accident and someone wants to challenge that lasting power of attorney. You then might have yourself in a position where you've got a donor who clearly had capacity and was not subject to undue influence. But because the certificate provider didn't do a great job, that instrument is then invalid, even though there is no dispute that the donor was capacitous and acting as a free agent. And this is where I have to say I depart from the judge's analysis, because she says that the certificate acts as a reassurance on a number of matters. But why do we need reassurance of matters that aren't in dispute? So in TA, it was accepted and there was no dispute whatsoever that the donor had capacity and was free from undue influence, and there was no other reason why it should be executed. Now, the certificate on TA goes to those issues, but they weren't in dispute. So we have a position where that was the agreed those were the agreed positions, that she retained capacity, etc. But the certificate provider didn't apply their minds to those issues. Well, I sort of come to why does it matter when those issues weren't in dispute in the first place? So it concerns me that that's going to be an outcome of the decision. But from a litigation perspective, I think it might be useful for those of you who are involved in contested COP litigation. Just have a think about whether you include this now as a ground for challenge to an LPA. Most applications are brought by the OPG, but there are many cases where they aren't, because she might not act quickly enough. And so I regularly act for family members where they actually have to bring the application to get it in the court process. Now, typically, a challenge to an LPA is usually on the basis that the donor lacked capacity at the material time. It's pretty rare to bring a challenge on the basis of undue influence, but I have seen it. Here, however, you might think about adding the challenge under 2.1e as your primary ground. Because if you think about it, it's actually, I think, it'd be a lot cheaper and easier to challenge a lasting power of attorney on that basis. Because all you need to do is really either the certificate provider doesn't provide any evidence, in which case they can't then evidence those matters prescribed in TA. Or if they do, you might be able to undermine that evidence with cross-examination, for example. But when you're challenging on capacity, you need to get the medical records. You usually need to get a retrospective capacity assessment as well. So the cost of that challenge are actually much greater. So I do, certainly I'm going to think about this in my cases going forward, about whether I add this in as my primary challenge. This is actually maybe going to get that objective for the client at more proportionate cost and perhaps more quickly. So those are the sort of key outcomes. I'm sure there are many more that lots of you have thought about. But next, just to hand over to Caroline and Neil. And if I start with Caroline, because Caroline, you've got so much experience in dealing with the ongoing consultation about the modernisation of LPAs, and I think everybody really interested to hear about that. How do you think this judgment sits with that ongoing consultation?
Well, I think I actually welcome it because I think that what it's doing is creating an interesting debate because historically the aim of the certificate provider, when I say historically, the aim behind the Mental Capacity Act was that the role of the certificate provider was essentially about ascertaining that the client had capacity, because the mischief it wanted to prevent was someone signing a lasting power when they lacked mental capacity or that they were subject to undue influence or pressure. And there was quite a lot of debate as the Act was going through Parliament to try and ensure that that was what was going to happen. However, what we ended up with is the opinion in Schedule 1E, which doesn't quite reflect what the intentions were of Parliament, because there's no reference to the functional test in Section 3. Now, the consequence of this might not be obvious. So it could be that a certificate provider, at the moment, the certificate provider is purely required on the face of the certificate to be sure that the person understands the purpose of the LPA and the scope of the authority that they're giving. Okay, so it's all about understanding. So you could have this odd situation that you had a client who understood the purpose and scope, but couldn't retain that during the decision making to make the LPA, or couldn't weigh up all the information. It would mean the certificate provider would be in a ludicrous position where they could sign the certificate to say, yeah, they understood at this moment. But unfortunately, they didn't satisfy the functional test in Section 3, which is a bit of an oddity. Now, what I would say is that if you've got the capacity to understand, retain, use and weigh the relevant information, then it should be a given, it's inherent in that you therefore would meet the satisfactory test of understanding the purpose and the scope. It's not been helped, of course, by the way in which the OPG have been, I would say, watering down information and the actual certificate over the years, because they've been driving this digitalisation agenda, which, okay, that, you know, there's going to be a benefit to all of this, and I might, if you want, I'll have some time to talk about this. But this is, you know, the way in which we're going to be moving forward with this will require greater information. Now, that's lost at the moment. So in 2015, when we had the most recent prescribed forms, we had a change of the certificate. The Act requires an opinion. The certificate in the LPA, the prescribed form, does not use the terminology that's set out in the MCA. It says, I certify, as far as I'm aware, at the signing of Section 9, the donor understood the purpose and scope. So your certificate provider, Faye, would probably have said, yeah, as far as I'm concerned, she had it. And she's being prompted not to make any questions because of the prescription of what the form says itself. Furthermore, up until 2015, there was information aimed at the certificate provider with the sorts of questions that they were expected to ask the donor. Now, it's just well, you know, as far as I'm aware, you know, and that's not good. You know, your client clearly had capacity at the time that, the certificate provider believes she had capacity at the time. And therefore, you know, on the face of it, that should have been robust. But actually, taking, you know, one case in isolation, I sometimes isn't great for policy. It's much better to have a robust system that everyone knows what is expected of them. And I think the outcome is that absolutely, and we know the OPG and the Ministry of Justice are working on this, there will be guidance in the future. When the Powers of Attorney Bill, Act, I should say, is in force, possibly later this year, there will be guidance for certificate providers. There will be an expectation the certificate provider is to talk and ask questions, to do something more than as far as I'm aware. I mean, what's sort of odd at the moment, and I expect that many people are unaware of this, and that is that although the regulations are prescriptive as in, this is the order in which you're meant to complete the LPA. These are the people who can or who can't be the LPA. There's no express requirement on the certificate provider to read or understand the LPA, to read or understand the prescribed information, although the form says you should read it. There's no requirement to discuss the LPA with the donor, although the form says you should have a discussion. There's no requirement to see the donor on their own, to see them face to face, to see the donor sign, to be a witness. There's all these sorts of things that actually aren't there, which if you really want to have a robust system to make sure that the donor has capacity, let's park the issue of understanding, then you would have expected that that's what it should have been. But what's happened is the whole process has been watered down to make it easier and easier to make LPAs. That's essentially what I think has been the driving force. The Ministry of Justice have a very much clear agenda. Lay people should be able to be the certificate provider. Well, that's fine if you give them the tools to do so. But if you take away the tools, you end up with situations like this.
I completely agree with that. But I think that's what's quite frustrating about the situation is that because as part of the appeal, we looked at the discussions in Parliament and the consultations for the draft 2005 Act. And there was an initial recommendation that for only professionals could act as a certificate provider, so either a clinician or a solicitor or barrister, and that was dropped because it was recognised that that would prevent, in some cases, people actually executing LPAs because of the potentially prohibitive cost of it. So the whole premise behind a lay certificate provider is to make it easier to create an LPA and to increase the uptake of them. But I entirely accept your point that if you're going to have that and expect members of the public to take on what is quite a serious role and that clearly carries with it some onerous duties, you've got to set out the roadmap for them to be able to do that. And that's where there's the lacuna at the moment, in that there really is no guidance. I mean, Sophie and I had a look on the OPG's website, and in the judgment, the judge says that certificate providers aren't there just to act as witnesses. That's not an argument we actually advance, that they were only witnesses. But actually on the OPG's website, they appear to describe certificate providers as witnesses. So their own information is completely contradictory. So hopefully with the consultation that there'll be some clarity and more prescriptive steps so that it makes it easier for individuals.
Yeah. I mean, what's been quite interesting on the consultation on the modernising of lasting powers was that, and that was 2021 that we had the consultation. The Ministry of Justice had taken the position that the role of the certificate provider was not to form, but wasn't required to assess capacity. It was purely focusing on understanding. And therefore, you could have a situation where the person had capacity, but if they didn't understand what they were signing, then the certificate provider couldn't do what was required of them. Now, whilst that might be a good position, what was far more worrying is, as I explained earlier, that you could have a situation where someone can understand sort of a key aspect, but not all of the aspects of making an LPA, and therefore they wouldn't satisfy the functional test. So you could sign the certificate, but you'd have an invalid LPA, which is a barking mad sort of stupid outcome to end up with. And so the Law Society, we took issue with this and eventually asked questions to ministers as the passage of the bill was going through. And the Ministry of Justice did a total U-turn and said, no, it's inherent that they must form a capacity assessment. But I think what's an interesting point point that this case raises, which is really, if someone has capacity and you're satisfied that someone has capacity, isn't it inherent that they actually understand that they satisfy the requisite requirement, which is that they understand the scope and purpose of the LPA, because that's part and parcel of a capacity assessment. I mean, that's what I would say.
Yeah, and we're also, you've got to draw the distinction, haven't you, between the ability to understand, which is what underpins capacity, and actual understanding. And I think it's going too far to suggest that a donor must have actual understanding of all the components of an LPA, because to me that seems overly protective of capacitous individuals. Because, for example, you don't have to have that with testamentary capacity, you just have to have the actual or the ability to understand when it comes to capacity. But it throws, sorry, Caroline.
Yeah, but my point really is quite simple, and that this arises under the MCA. So, testamentary capacity, the process of doing it is sort of slightly different. We've got a test, a very clear functional test to demonstrate understanding.
Yeah, and I think one of the aspects of this case is that inevitably, when the COP's deciding them, you have somebody who now lacks capacity, and the COP's role is to protect those individuals and make decisions that person can't make for themselves. But sometimes in that protective role can get lost that this person has previously made a capacitous decision, and that should be upheld, even if there are now, because I think the background to all these LPA cases, if there are concerns about safeguarding, or that one sibling has been in mum's ear to say, oh, do this, do that, I think that inevitably affects the judge's assessment of matters, and it can be quite difficult for them to demarcate capacitous pre-COP decisions with what the judge is being asked to do now. And I mean, Hayden says a lot in his cases about not falling into that protective, overly protective role, and that LPA should be construed in a way that upholds capacitous decision making. But just moving to you, Neil, what do you think that this decision undermines, or has the potential to undermine, capacitous decisions made by free agents?
In short, yes, I do. In fact, what you were just covering then, in terms of what it's looking at in terms of affording protection to the donor, I had made some notes after the judgment, and notes I'd made during when we were dealing with the case, and I thought, is it too protectionist? Because I remember going back in time now, there was a spate of cases decided by Senior Judge Lush, he then was, where he looked very closely at various aspects of property and affairs cases under the light, of the European Convention of Rights of Persons with Disabilities, and raised the question of, is the law in the UK too paternalistic, too protectionist? And I think in this case, it's arguable, and it raises that concern that, here we have a case where the fully capacitous donor, not under any undue influence, these were the facts of the case, that has had their wishes defeated. The second thing there's a danger of happening is to further, disenfranchise the donor from having a free choice of who acts as their certificate provider. Because what we've got here is, in the case, the judge at first instance says the certificate provider is to take some steps. And in the OPG's submissions, they were talking about requisite checks. It's all nebulous language. And the danger we have is there'll be this arbitrary threshold set by the OPG that becomes very difficult to have any certainty about, and you'll have lay certificate providers put in very difficult position, because there was a lot on social media And, some solicitors were saying, well, I would never dream of not taking any notes, in acting as a certificate provider. Well, yeah, we're talking about lay people, and the donor should have the right to choose who they want to act as their certificate provider. But now, it's defeating what was really intended by the Act and the current, Powers of Attorney Act from 2023, and broadening this out to, increase an uptake of LPAs, is that there's, the certificate provider is going to be in a very difficult position.
Yes, I think that's right. And I think it can't be underestimated. And Caroline and I were discussing this before about how significant LPAs are to individuals. I mean, it's perhaps a more sophisticated decision in most cases than making a will. And the power that you're conferring on a person, on your attorney, is really significant. And that's why in the RI and public guardian case, which was from 22, before Mr. Justice Poole sets out the relevant information that the donor must have the ability to understand, and that includes the scope of the authority and power that's conferred on the attorney. And we've all, probably all seen those cases in practice where attorneys have behaved badly and they misappropriate substantial funds, and then there's no bond to kick in like there would be with a deputy. So when it goes wrong, it goes horribly wrong. And I've got a number of ongoing cases where trying to desperately recoup some of the money so that people's care bills can be paid. And so when people make LPAs as capacious individuals, most of them really think about the person that they want to give that level of authority and power to. And I think it's a big step to remove that capacitous decision from a person on the basis of a lack of compliance with formal validity. That's where that judgment just doesn't sit quite right for me. So I think, sorry, Neil, go ahead.
No, it's fine. I mean, I think that's this current Law Society guidance for solicitors, but it's been out for a few years, that, really highlights that when you're talking to your client, be careful about who you choose as your attorneys. So that safeguarding bit, that's already there.
Yeah, absolutely. Okay, well, I think given the time, we'll leave it there. Just to say a huge thank you to Caroline and Neil for joining us. It's so useful for people to hear your respective insights on the case and on sort of more broader matters. I've just been checking the chat. No one's raised any questions that I can see. The last slide, I think Sophie has got our email addresses on it. It hasn't yet. There we go. So if anybody has any questions about the case or about any broader issues, then do feel free to get in touch, and we'll do our best to deal with those. And we hope over the course of the next couple of months, actually, in Chambers, to put on a number of different seminars that cross both the health and welfare and the property and affairs jurisdiction. I've got actually some quite significant cases, hopefully, fingers crossed, being handed down in the next couple of months in the property and affairs jurisdiction. So we'll be sure to do some up-to-date seminars on those when those are handed down. You mentioned about the attendance note including questions for the certificate provider. What would you suggest? I think you've got to, there are those cases where you have a client and you think, oh gosh, I'm a bit worried this person has capacity, but or whether they lack it, or that there's issues with under influence. And so you go that extra mile with your questioning and your attendance note. I think in a way, if I were doing it, I would be approaching it like that. So there's got to be an active inquiry into matters. So you want to be perhaps in advance of the meeting, sending them out the relevant information about the lasting power of attorney, and so that when you actually get them in your conference, you can test their understanding about the relevant factors. So have a look at the case of RI and public guardian. I can't remember the specific reference. It's from 2022. And at paragraph 16 of that decision, Mr. Justice Poole sets out the relevant information for capacity to execute a lasting power of attorney. So that's a really good starting point to direct your questioning to just it enables you to assess whether they understand all those various features. So I would probably be formulating my attendance note around that. And then with undue influence, you want to be looking at things, have they changed attorneys from a previous LPA? And if they are, why are they doing that? And make those kind of inquiries to be able to demonstrate that they're acting as someone freely. Caroline, Neil, if you've got anything to add, please do jump in.
What just to give some reassurance that there will be in the future guidance specific to all certificate providers as to the sorts of questions that they should ask. There is, there are sort of various bits out there. If you're a member of, it's not called Solicitors for the Elderly now, but they have a pack with questions, and there's lots. In my book, there's lots of sorts of things in there as well. In the public domain, there is information. What I might share with you, Faye, is I might actually let you have the former guidance from the OPG, which I still have. Just as a side on this, where I was having a conversation, this was about 2 years ago, with the OPG, moaning that there was no guidance for certificate providers, because I said it puts people in a very difficult position, not knowing what questions to ask. And I said, why did you get rid of your previous guidance? They said, we didn't know we had guidance. And it really shows the poor memory, institutional memory of the organisation, that they drafted guidance, got rid of it from their website, and no one knows about it.
Me at all.
But that's the sort of thing. A lot of it is common sense, really, is, do I understand who I'm appointing? How are they going to be acting? When are they going to be acting? What sort of decisions will they be able to make? What sort of decisions don't I want them to make? When can I cancel my power? How will my attorneys be able to act? In other words, do I realise that they have to act in line with the Mental Capacity Act? Those are the sorts of questions that you would expect to ensure that your donor understands. And I would always suggest doing it by reference to their real life. I have done, and it's probably useful to flag up, on the MenCap Trust Company website, I have easy read versions of sort of explanation notes, aimed primarily, of course, to people with learning disabilities, but it's not limited to them. And there is guidance for certificate providers there that I've drafted as to the sorts of questions. So if you go to the MenCap Trust Company website or you type into Google, guidance on making a lasting power of attorney, you'll see the pack there of the sorts of questions. And there's easy read versions, because I always think that the problem about LPAs is that it's terminology that people aren't familiar with. It's great if you're law and you understand it, but for most people it's gibberish. And so it can help all sorts of people to be able to understand and navigate the LPA creation. But we'll of course have things later on, once the digitalisation comes into effect, there'll be far more available there for people. But that's what I think we should do in the meantime.
I think just to add to that, where I find solicitors go wrong when I deal with this in litigation, so I see it when I'm cross-examining solicitors on what they have done, and many will. It's clear that they are addressing the right test or the issues, but their recording is so-and-so understood XYZ, understood XYZ. And when you're then challenging that in litigation, it can become very easy for a barrister to cross-examine you, because that's not demonstrating their actual understanding. And I do this in my statutory wills where I'm dealing with wishes and feelings. I like to have almost like a question answer, so you can actually see whether someone is understanding various issues. And so that's how, if I were approaching attendance notes, I would, and I appreciate that's a huge task, And you would really only do that in the case of someone where you were concerned that capacity were an issue. But just I find that sometimes the support to the trap of just saying something very generic, and that actually isn't that helpful, but can be easily challenged if you're in litigation. There's one question here that says, if the certificate provider is deceased or not contactable, where does that leave the donor? And that's one of the difficulties now, I think, because for example, I've had cases in the COP where somebody's challenged capacity and we haven't been able to find the certificate provider, or they have died. And that obviously affects the evidence that is before a court. And it's a gap in the evidence that if you're trying to demonstrate capacity can be unhelpful. It's not insurmountable, because there may be a wealth of other medical records, for example, and lay evidence from witnesses. But here, under this decision, where you actually now have to go beyond the certificate and demonstrate the checks, the properly formed opinion, that might be quite difficult if your certificate provider is no longer around. And so that is why I do question whether that's going to be a much easier ground to bring a challenge. And so when you are advising clients who are going to deal with the execution themselves, I think it might be very sensible to encourage that certificate provider to keep notes of what was done and what was asked, because that would have an evidential weight, even if they subsequently passed away.
You're quite right. But what's very interesting, there is nothing in the legislation that requires a certificate provider to respond to the public guardian's request for information. There's nothing.
I was going to make the same point, because I think, Faye, during the proceedings, we had a discussion, and one of the things, we were looking at the various injustices that might be caused. And one of them was, well, what if the certificate provider had decided not to respond to the OPG's letter? All they would have is a certificate complying with the Act.
Yeah. And so that going back to the example of somebody like me who might have an LPA, if that certificate provider didn't get in touch, but it was clear that at the time I had capacity and were acting as a free agent, to me there seems a real injustice in then that LPA being rendered invalid. I'm just having a look at some of the other questions. Caroline, I think people are really grateful for your indications of where to have a look at various documents that you provided. It might actually be helpful if you could provide me an email just setting those out, and I will send that out to everybody so that everybody's got those. I think people are going to find that really, really helpful.
Yeah, there are lots of resources around.
This almost just said, as of interest, I've had professional certificate providers refuse to comply with requests unless paid. I mean, if you're signing acting as a certificate provider in a professional capacity, then really you've got an obligation to comply with any requests for information, in the same way that if you were doing a lark or you were being called as a witness in a probate trial to give evidence as the solicitor who prepared the will. So so you might want to go back with that, but also sometimes people have in their retainer letters things about charging for things. But I think given the time, we'll leave it there. If there are any other questions, please feel free to email me. But as I say, I'll send out an email with as much information as we can to help people. But as I say, once again, thanks very much for attending, and have a lovely evening.